Okay, we'll go ahead and get started. Good morning or good afternoon, wherever you're located. Welcome to meeting DFARS 7012 compliance deadline with data discovery and data classification. Joining us today is Scott M. Giordano. He's our guest speaker. Scott's a well-regarded data privacy attorney who has more than 20 years of experience. He's developed the first law school course in electronic data discovery and currently is licensed attorney in Washington State, California, and the District of Columbia.
Good day, good morning, good afternoon to anyone, wherever you happen to be. So what are we going to talk about today? We are going to talk about four big areas, if you will. What is DFARS 7012? We'll talk about the National Archives and Controlled Unclassified Information. We'll then segue into the realm of data discovery and classification and all of its virtues, and then finally I'll give you a bit of the road ahead, although I may give you bits and pieces of the road ahead as we go through this whole presentation. And just an FYI for everyone, if you have seen previous discussions about DFARS 7012, perhaps you've seen another webcast, or maybe you run a webcast that I was on a couple weeks ago with Bob Metzger and Mark Lippin, we're not going to take as deep a dive as Bob did into DFARS 7012. So some of this may be review for you, but really I'm hoping to tie together DFARS and NARA and CUI and data classification and discovery all in one package. So that's what I'm hoping to do, but please do ask questions as we go through, and we'll make sure to get to them. So with that, let's go to the next slide, Doug, if you will. What is DFARS 7012? The official name, Safeguarding Covered Defense Information and Cyber Incident Reporting. That's the official one. I just call it DFARS 7012. It's a rule imposing information security controls and reporting of information security-related incidents on contractors and subcontractors. So two requirements it has. One, providing, quote, adequate security, and we'll talk more about just what they mean by adequate security. And then two, you have to notify DoD within 72 hours of a cybersecurity breach. So those are the two things that it asks for. And what's interesting is the 72-hour rule happens to be the same standard that is being used for the General Data Protection Regulation overseas. That's something that I find very interesting, that they're using the same standard for reporting a cybersecurity breach. So more on that later. Just by way of understanding what they're getting at, they put in the Federal Register that the objectives of the rule are to improve information security for DoD, information stored on or transiting contractor information systems, as well as a cloud environment. So the initial rule was published in November 2013. There's been two interim rules since then, in August, December of 2015, and then the final rule was laid down October 21st, 2016. The deadline for compliance, which I do not think is going to be changed, is December 31st of this year.
Scott, a question. If the initial rule was published in 2013, why is it just now being implemented?
What's interesting about this is that way back when, the initial rule required the non-federal folks, the contractors and so forth, to use NIST 853 as their security standard, which is a very high bar. I mean, you need the resources of the federal government to be able to meet those kind of standards. And even well-heeled organizations just aren't going to have the time and the money and the resources to meet that standard. So as so often happens in this industry, they pushed back. And they said, wait a minute, we can't meet that standard. So there was a lot of pushback by contractors, and they said we don't want to be locked out of this because simply we're not going to adhere to 853. So NIST came along and said, okay, great. Here is a much more achievable set of standards, 800-171, which is focused on confidentiality. So the net of it is, and this is, again, very common, contractors push back, industry pushes back whenever it gets something it doesn't like. Sometimes that works, sometimes it doesn't. Here, it did. So hence why we're almost 4 years into this. Here, another interesting idea here is this a law or regulation? And the answer is no. This is part of the defense FAR Federal Acquisition Rules Supplement, part of their inherent authority to make rules in the purchasing process. So 2 clauses, I mean, there's actually more than 2 that are involved, but I'm just going to cite these 2. One is -7008, which tells you that you have to maintain compliance with requirements set forth in -7012, and that it has to be used in all solicitations by the government. And then, of course, in 7012, that's where the meat of this is. It provides for adequate security and then cyber incident reporting. And so, again, this has to be used in all solicitations and contracts, and it has to be pushed down or flowed down, as we say, to subcontractors. So that is this 7012 clause, basically the 2 halves of it: adequate security, which is measured against 800-171, and which I won't be spending a lot of time with on this broadcast, and then cyber incident reporting, which is part of another set of requirements. This is the interesting thing about 7012, is that a lot of folks think, oh, it's just 800-171 and that's it, and the answer is no, that's not the case. There is a laundry list of other things you must do, like having a cyber incident reporting mechanism, being able to isolate if you are attacked and say there's malware on your system, being able to isolate the malware, put it in a safe place, and give DoD the ability to go look at it. Also preserve images for 90 days. And there's a laundry list of stuff you have to do that people have been overlooking. I'm kind of concerned that they're going to be 171 compliant and nothing else. So, but we'll come back to that as we go through this. So
we have a question,
slide.
Scott,
regarding
this slide. Yeah. So why don't we have a national cybersecurity statute or regulation?
Mm-hmm. Why don't we? That's a fabulous question. It should have been done a long time ago. Really, it's a political issue. That you would think that we would have something like this far into the internet world, as it were, and we don't. We have the cybersecurity framework, but again, that's a risk management framework, and it's voluntary. It's highly encouraged. The FTC encourages it. A lot of people encourage it, but it's not law. My guess, and I'm kind of maybe showing the road ahead a bit, is that this 800-171 confidentiality standard may wind up becoming a de facto national cybersecurity standard, which would not be bad, but it would be nice if we had it done legislatively. I just don't see that happening with all the contention in the federal political world right now. Let's go and see, to whom does this apply? Not surprisingly, if you're a prime, yes, this applies to you. If you're a sub, yes, this applies to you as well. So contractor has to include the 7012 language without alterations in contracts, agreements, etc. And also, interesting, requires the subs to notify them if they're asking for a variance in the security requirements. So variance meaning that you have a laundry list that controls in 800-171, and if you believe that the control does not apply to you, or you have a better one or a different one or what have you, you can ask to have that okayed by DoD instead. And so you have to push that up to your prime or to whoever's in the next link in the chain above you to make sure that the ultimate prime gets to know just what controls are or not being put in place. So does this apply to so-called commercial off-the-shelf software, like the stuff that you drop into your cart at Costco? The answer is no. Luckily, that was an exception. So you do not. This does not apply to that. Luckily. Also, do you have to be a defense contractor? Again, this is an interesting point. This rule applies to pretty much anyone that is holding, that's not the federal government, that is holding this federal government data. So if you're a state and local government or a tribal government, or if you're a university, for example, you may have this kind of data. It applies to you. So if, again, you don't be a defense contractor, in quote, because it may be that you're a sub to a prime. You're not a quote-unquote defense contractor. You're at a university doing research, for example. It still applies to you. So again, this is one of those areas where it's very easy to get off the rails because you think that, oh, I'm not a defense contractor with a capital D. So that's not the case. Thank you. So covered defense information. What does that mean? And the whole idea of covered defense information has gone through so many twists and turns over the years. I know when I was working in trade compliance that there was just different flavors of this that were being discussed endlessly in a trade compliance context, and now this context is in a DoD purchasing context, which is different but related. So covered defense information, CDI, is unclassified controlled technical information or other information described in the Controlled Unclassified Information Registry that we will talk about in a minute, that requires safeguarding or control, blah, 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 consistent with laws, regulations, etc. Now, here's what's interesting is that you've got two flavors of this. You've got the case where it's marked or identified in the contract, and it's provided by the contractor, or I'm sorry, provided to the contractor by or behalf DOD in support of a contract, or, and this is an important or it's collected, developed, etc., on behalf of the contractor in support of the performance of the underlying contract. Now, now you may say, well, okay, who has to, in that case, who has to market? Or in either case, who has to market the data? We're just presuming that it's the DOD has to market, or it's the prime. The answer is we don't know. So this is an important point for all of you to take away, is that right now it's not clear who gets stuck with the marking process. It's not enough to say, well, if it's not marked, I don't have to deal with it. Not true. Because here you can see that if it's collected, developed, etc., in support of the performance of the contract, you're still in scope to be able to be responsible to do that. So this is a big unanswered question right now, and we'll talk about the importance of marking and so forth in the course of our presentation today. So let's go to the next slide, Doug, and let's talk about the NARA CUI Registry that I just mentioned earlier. I know this is an eye chart. I don't expect you all here to read this thing, but I would ask you to take a look at it after we get off the call today. Let me roll back a little bit in terms of time about how this all started. This started back in November of 2010 when President Obama issued Executive Order 13556, and that was called Controlled Unclassified Information. Not surprisingly. The idea was to establish, I'm quoting here, establish an open and uniform program for managing information that requires safeguarding or dissemination control. So essentially it's creating a standard for marking all kinds of confidential information, we'll say, or sensitive information. This order created the CUI program. It designated the National Archives, NARA, as the CUI executive agent. So the folks that essentially have, you would think, the last word on what is a particular category, what is the definition, all of these things. NARA published this final rule. This is a rule that's applicable to federal agencies. Published this in September of last year, so what, barely 6 months ago, so fairly recent. There are 23 categories, I think 23, 24 categories of CUI, and there are 84 subcategories. So again, if you take a look at the screen here, you're seeing that on the top we have controlled technical information, we have critical infrastructure, emergency management information, export control, and so forth. So all kinds of different categories of information that the federal government could produce. And so again, we're not going to go through all of these in our discussion, but again, I asked you all to take a look at this when we finish. So this final rule that created this whole thing the final rule that NARA came out with gives the agency the ability to designate information as CUI if it's not expressly prevented from doing so. This rule, again, published nearly 6 years after the executive order. So nothing moves fast in the district, not surprisingly. So if we go to the next slide here, we'll get a little more deep dive on CTI, Controlled Technical Information. And I want to read the whole thing. I'll just read the first paragraph. So again, technical information with military or space application that's subject to control on the access, use, etc. So what's interesting about this, a couple things, is that if there's any folks on here from the trade compliance world, you're saying, oh, wait a minute, so this is necessarily going to be ITAR or EAR controlled data. And the answer is, well, that's a great question. Because it looks like it. I mean, when you see things that say, distribution statements, B2F, oh, this is the same thing as ITAR, right? Not necessarily. Not necessarily. Which we'll see in a minute, there's its own category of export control data. So why do we have two categories that look very similar? That's a great question. I don't know what NARA was thinking, but I'm sure they had a good reason for doing it. So just so you all know, there actually is an export control category on to itself. Under CTI, there is a marking requirement. The marking is CTI. So what's interesting now is that this document, say that you had a CTI document that contained military space application, somewhere it's got to be marked CTI. Now where? That's a great question. Again, we don't know. Should it be in the footer? Should it be in the metadata? Should it be in the file name? It could be in all three of those places. It probably should be. Right now, we don't know where it necessarily has to be marked, and again, who has to do it. And if who has to do it doesn't do it, then what? Still too early to say, but this is a good example of a marking that needs to be in this. So if you go to the next slide.
Scott,
yes.
Just for the benefit of our audience, is this marking system going to apply to all organizations that hold federal government data?
Yes, it does. Yes, it does. And so what's funny about this, again, so few folks know about this, is that right now DoD is the only one that really take advantage of this. But in principle, in the near immediate future, you should find that other federal agencies are going to be asking the same thing of organizations, not federal organizations that are holding federal data, and asking them to mark all of this presumably if the feds haven't marked it themselves. So I'm almost certain this is going to become a just universal standard for marking, and it's going to be all government agencies. It just happens to be that DoD pushed this initially, but we're already seeing now, for example, for better or for worse, the Department of Homeland Security has put together their own scheme for CUI, which a little bit runs counter to this one, which they shouldn't be doing, but that's a different discussion. So we are seeing at least DHS is taking an interest in this kind of thing. I suspect we will see other ones follow suit after the end of the year. So let's go to the next slide, Doug, and let's talk about other examples. So I mentioned to you folks earlier about export controls. Is there a separate class? There is, and notice the marking there is EXPT, unless it's basic research that is export controlled and subject to ITAR or the AR, and so it's export, or it's EXPTR. So you can see that this requires those kinds of markings. So this is completely separate and above anything the state is requiring. So again, if there's any trade compliance folks on here, this is beyond what state or commerce is asking of you. This is a separate animal. And presumably, if you've been given this data by the government or by a prime, you're going to have to use this marking system. So, so again, a bit of a surprise for folks. I don't think that they've realized that this is going to be a requirement. So other examples, and I really wanted to bring this one out because this is privacy-related information. So privacy is personally identifiable information is defined in OMB M716, which has changed, by the way. They've updated that that rule from OMB, but it's still essentially the same definition of personal data. So different species of personal data. So genetic information gets genetic as its marking. Healthcare gets HLTH and so forth. Student records get STUD, which is personally my favorite marking here. The feds have a sense of humor, clearly. So these are all the kind of things that you're going to be required to be marking at some point in the future. And again, when we wrap up the call, please do take a look at this registry. You're going to find that there's a lot of work to be done, quite literally. Let's change gears and talk about finding classified and controlled unclassified information. I'm doing it again, using the data discovery mechanism. So data discovery, let's talk a little bit more about what that really means and what it's not. I think there's a bit of confusion about that. So with respect to finding controlled information, whether it's CUI or personal data, what have you, data discovery is the process of locating specific types of data in your enterprise ecosystem in order to accurately protect or remove them. And I use specific because it doesn't necessarily have to be sensitive or regulated data like we're talking about here, although likely that's what you're looking for. So your big targets are going to be file shares and email servers, SharePoint, cloud everything, not surprisingly. All those things are going to be good targets of data discovery. So now, is that the same thing as e-discovery? And the answer is no, and I speak from some knowledge here, having worked in e-discovery for many years. E-discovery uses just a different principle. It's creating an index of data for a specific repository. It could be a SharePoint site, it could be a file server, but creates an index, and then you go search the index looking for documents that match keywords you're looking for. Oftentimes, they'll use a Boolean search algorithm or something of that nature. The difference is that data discovery is real time. You search it and just see what the state of your ecosystem is at that moment. It doesn't create an index, which is an advantage in some ways. It's not file classification. For those of you that are from the information governance world, file classification is a great technology, but really it's very metadata specific. It's geared toward eliminating things that are duplicative and so forth, really not data discovery. So let's talk about data discovery in action. Those of you on here probably have used things like regex or grep or any of those tools, or Boolean, for example. The problem with all that is that they're nice tools, but they really were not well geared for doing what we're doing. And I'll give you an example. Go to the next slide, Doug. So here I'm going to use an example just of credit cards, because that seems to be very popular nowadays. If you did a regex search, for example, for a 4 plus 4 plus 4 plus 4 pattern, you would get all kinds of things, okay? And any pattern can do that. Regex can do it. I'm sure there's other tools that can do it. I'm familiar with regex from my e-discovery days. The problem is that it will grab anything that has that pattern. So if you look on the left here on the screen, you can see that area that's boxed in, again, matches the requirement there of those 4 plus 4 plus 4 plus 4 digits from 1 to 9. But if you look to the right, you can see that what that translates to, it's not a credit card number. That's just how it resolves. So the problem is that it's very easy to find false positives, and it's a huge waste of time. It just doesn't do a very good job. Also, suppose that you want to suss out things that have a $ sign in front of them, for example. This won't do that, or won't do it very efficiently. So again, a good example of how you will get all kinds of false positives, and it's just, after a while, it's not useful to use a regex or a tool like that. If you go to the next slide, Doug, we'll talk more about this whole idea of data classification. So we've talked about data discovery. Now data classification, and I'm going to show you guys the data classification scheme I developed. You'll see this in a minute or two, that I developed. I've cut it down a bit to de-identify who I did it for, but it's a real data classification scheme. Data classification, here I have the official definition of it, if you will, of analyzing a document or record and applying a label, or in this case it would be a marking, we would call it, that indicates who can access it, how long it should be protected, how long it should be retained, how it should be disposed of. So all of those things are baked into there, and it's a process, and I emphasize the word process because it involves regulations like DFARS 7012, or if you're multinational, General Data Protection Regulation, or if you're a medical institution, it's HIPAA, high-tech, etc. So it involves regulations which beget policies. We shall do this, or it's our policy to do this. Creates a list of expectations, the to-do list that a good policy will create effectively, or force you to create, and then the controls, the things that enforce and prevent bad things from happening. So the policies, expectations, and controls piece of this, these are things that are developed over time, and they are an iterative process. You try a policy, you create your set of expectations and controls and see how it works. You test them routinely and see if they actually do what they're supposed to be doing. Hence, that they always have to be repeatable and defensible, so that if something goes wrong, you can always go into court or before a regulatory authority and say, look, we did the very best we could do with what we had. Here's what we did. One of the great comments that CISO I used to work with said, he always liked to say, there's always a lawyer. And by that we mean that in all of these information security and privacy regulations, there's always legal aspects, and this always has to get run through legal. And in fact, the reason I created a data classification scheme is because information security folks would not do it without busting legal, because it had to be enforced company-wide. So hence, there's always a lawyer. I didn't make that up, but I just wish I did. If we go to the next slide, I believe we are, okay, I will do why data classification, and then we will dive into what a data classification scheme looks like. So the why to it, not surprisingly, it answers all kinds of questions. It's about control over your information in the ecosystem. Once you've discovered and classified the data in the system, you've really multiplied the number of options that you have over data. So it answers questions like, what do you have, where is it, who has access, how is it controlled, how is it retained and disposed of, which, not surprisingly, is the kind of questions that you will have whenever there is a breach. And eventually there will be a breach. It's just a matter of time. There's really, as I like to joke, two kinds of companies, those who have been breached and those who have yet to be. So being able to answer those questions really speeds up the notification process to 72 hours, whether it's for DFARS, whether it's for GDPR, or HIPAA, high trust, anything for that matter. Data classification creates consistency, so you're not taking the same kind of data and classifying it differently, therefore giving it different controls and potentially having one get less control than the other, even though it's the same data. So also enables you to justify and prioritize your controls, so the most expensive ones, or perhaps the most efficacious ones, are the ones that get purchased first. And as I mentioned earlier, in the event of a breach, or there's some kind of internal investigation, and I've been involved in plenty of those, it really helps you prioritize your efforts, because you can determine, for example, what is ITAR control data, which I know in my past life, being able to identify that very quickly and definitively can really save you so much time. So potentially you may have data that wound up overseas that, because of export control regulations in the host country, you can't get it out once it's been there, and you actually would have to fly over there, as I almost had to go and look at it. So being able to have this as a part of your metadata, this marking of export control, really would have been a huge, huge help back then. Let us go. I believe we have the next slide is the 4 components of data classification, and then I really will get to the scheme in just the next slide. So you have 4 components here. One is the matrix, which we'll show in the next slide. The matrix really is the, if you will, intersection of a particular sensitivity of a kind of data and then how you're protecting it. So it could be that if something is especially sensitive, that it only, for example, could be transferred using secure FTP, or it can't be faxed, or it can only be viewed by certain people. We'll talk about that in a minute, but essentially it's a table that revolves how everything should be protected. Policy enforces that. So policy is going to cover all of the things, all the particulars. So who's responsible for implementing the matrix? How is it enforced? There should be a data classification committee that resolves all of the disputes. I know that we had a committee that was probably had about a dozen people on it across 2 countries. Because politically, once you start putting controls on things, people get mad, and so you have to be able to explain why you did it. There's the tools, like, not surprising, like Spirion, that enforce that. And then there's monitoring and audit. So the process of doing an audit periodically and saying, hey, did this tool really work? Can we compare it to maybe things that didn't work and see why it didn't work? So those are the 4 components of data classification system. And as I mentioned earlier, the matrix, which is our next slide here, is the core of that. So without further ado, we can take a look at this. And this is based on a real system. So I did not make this up at whole cloth. This is something I took and cut down just to protect the former client. But essentially, this system, you have 4 different bands here. Things that you would expect would be in the green band, or things that are publicly available. And so if you look to the 3rd row, where it talks about the severity of the consequences of mishandling, if it's green, then there's no severity. It's something that's meant for the public. Whereas for the blue, it would not significantly impact the company or stakeholders or employees and so forth. But as you move up in the color scheme, you can see that for yellow, it could result in significant adverse impact. And then for red, it is likely to result in significant adverse impact. So that's the touchstone. And if you say, well, Scott, that looks just like FIPS 199 or something like that, and that whole thing, it does. I didn't borrow it from that, so just that, just so you know. But yes, it does look like that because we're using the same logic essentially. So each of these will have its own controls summary. So, for example, if something's in red, special categories of special data, non-U.S. So that could be things like healthcare information in the EU. It could be information about someone's sexual history, for example, trade union membership, religion. These are all very radioactive topics in the EU, and so that's special data, and that to release that data, someone has to give explicit permission, and so in terms of protecting it, you would say, well, we're not going to have any transmission via fax, because, as you know, faxes tend to wind up everywhere. It has to be restricted to named individuals and groups. You have to put notices in there, et cetera, et cetera. So this is a good example of how a real data classification system works. And if you go to the next slide, you'll see that we drill down to more specificity as far as different media. So in this one, this is electronic media. So email sent between offices, email sent outside your office. There's slightly different controls for that. For electronic file transfer, it's got to be encrypted, and it has to be, the encryption mechanism has to be approved by the classification committee. So again, you're using consistent encryption methodologies, for example. It can't go into a web portal unless there is an approval. It can't go into the public internet, for example. You can't throw this up on the company website if it is Class 3 or Class 4, and so on and so forth. If you go to the third slide in this series here, okay, so you'll notice that I have this little window which shows some files and how they've been marked. And you can see the different, and this is how Spirion works. It marks these things so that you can see it from a visual standpoint. It's also buried in the metadata as to the classification, so it's machine readable. But you can see, so on the far left, company profile is in green, correspondence is in blue, and so forth. So these different document types, different classes of documents, will, by their nature, require different levels of protection, and therefore when you hook in these classifications to a system like a DLP system, it will enforce that. You have to bake the rules in, but it will enforce that. Doug, I've been talking really fast for the last 50 minutes. Are there any interim questions or comments or thoughts about anything?
Nothing's come up since the last set of questions, but I would just want to remind people, enter your questions in the questions tab. We'll get to them immediately.
Okay. Okay, fabulous. So let me start drawing down to the conclusion, and I'll give you some thoughts about this whole thing. If we go to the next slide, why is data classification critical? Really insidious and subtle example here of a PowerPoint. This is a PowerPoint deck that was, I believe, created by Jeb Bush, the then governor of Florida, created this, and it's really innocuous. It's some kind of chart or graph about something, and as all of you know or suspect, that when you use things like object linking and embedding and what have you, it brings the entire spreadsheet in to an object, and if you click on it, it'll reveal the whole thing. And I know in the past this has created some embarrassment at places I've worked at, where people have taken a spreadsheet and made a chart out of it, thought they were just saying the chart, and really they were saying the whole darn thing. And so this is exactly what happened here, is that in Jeb's administration, someone created a chart, and based upon a spreadsheet, it just happened to have all kinds of names, social security numbers, and again, because it doesn't jump right at you that that's the case, you can send the chart as they did in the PowerPoint deck, and of course the personal identifiable information was there. So it's too difficult to try to look for all this on your own. I mean, I've just had this happen so many times where things slip through like this, and you say, well, how did that happen? Why didn't someone check that? In fact, I think here locally, Boeing had that issue a couple weeks ago where same exact thing happened, where you had a spreadsheet with hidden columns that had SSN data that was emailed outside the organization, and they had to go report it. And it's too easy to miss this stuff. And so hence why having a system of data classification and discovery, being able to go and check this stuff, mark it as personal, mark it as export controlled. I mean, you may have a file that has 10 different markets, quite literally, because it could have so much data in there, and you've got to mark it all those different ways, whether it's export controlled, CTI, personal, et cetera, et cetera. And so it just becomes so complex, it's impossible to do this on your own. You really have to be able to have a system that will go and check this and enforce it. I know when I was working on this at a defense contractor, once this system was to be put in place, then your email system will be hooked into it, and it would simply block if you were trying to export anything that was ITAR controlled or EAR 900. It would just block it. You just said, sorry, we're not going to, you can't email this, because it's not unusual for folks to want to email stuff to their colleagues over in other countries, and they may not be ITAR capable. And so it's very easy to get in trouble like this. So it's just one of these pernicious problems, and this is really the ideal way to address this, is to have a system that will go look for stuff, mark it, look for markings, hook into a third-party system like a DLP system, and enforce all of your rules, and then go and test that through your organization and make sure that it actually works in practice. So that's really why classification is critical. And I'm going forward, I don't see a better way of keeping tabs on this. And whether our discussion today was DFARS 7012, it could have been anything. It could have been HIPAA High Tech. It could have been the General Data Protection Regulation, which is very difficult to work with right now. It's going to require a lot of effort. This is going to be the norm for multinationals having to deal with personal data and for controlled data, like defense-related data. And it's going to be for organizations that really didn't think themselves to be particularly susceptible to government regulation. You could be just a software company that's manipulating data by a party that is a subcontractor to DOD or to any federal agency. And guess what? Now DFARS 7012 applies to you, and hence why these mechanisms need to be in place. Doug, questions or comments from anyone? I know I've got about 5 minutes left, and I want to make sure I'm giving everyone a chance. And if not, I will talk about the future.
Nothing at this point, Scott.
Okay. Okay. Just some final thoughts on DFARS 7012 and data classification. My suspicion is that once this goes online at the end of the year, we are going to find that other agencies are going to start picking up on this, and that NIST 800-171 is going to wind up being a de facto requirement. I say that because NARA has made it a de facto requirement, or just a requirement to be able to comply with the CTI rules. And so as a consequence, other agencies are almost certainly going to do the same thing. Again, I'll put DHS aside. I'm not clear where they're going with this, but I think other agencies are going to do this. And as a consequence, we're going to find that 171 is going to become a de facto information security standard. And again, it really applies to confidentiality, but still, it's an important aspect. And I think this has the best chance. I know that cybersecurity framework is very well regarded, but again, that's voluntary. And again, it's a framework that still relies on specific control sets like NIST 53 or ISO 27K or top 20, those kind of things. This is essentially, I think, going to be a de facto rule because that the way that it's been set up by NARA and being implemented by DoD, and now I suspect by other federal agencies. There's no reason why they wouldn't do it. So the groundwork's already been laid for them. So I think we'll see that, and I know that that there's going to be coming cybersecurity legislation or rules coming down the pike from the new administration. Don't know when that will happen. I know stuff is being worked on. I don't know what that means or when we'll see something, but I would be shocked if we didn't see something by the end of the year. The end of this year, that is to say, because there's so much going on right now in the cybersecurity space. There have been so many embarrassments that really, I think the government really wants to try and get around, and they're always looking for the weakest link in the chain, which is going to be typically a contractor or a third party. That was certainly the case in some of these big hacks at non-federal systems, retailers and so forth. It was the third-party contractors that were the weak link in the chain, and so I think as a consequence, you're going to find that the federal government is using the same logic, and they're requiring all these folks to protect confidentiality. So I think that I'd recommend everyone take a look at the NARA Registry and 171 if you haven't already. It's not bedtime reading, but very important, and I think that making that a core part of your information security program, I think, is going to be huge, especially if you have to comply with the General Data Protection Regulation, because that requires you to put up a pretty stiff set of controls. So that's what I have, Doug. I know we've got a whole 2 minutes or so left, but I wanted to just make sure I didn't go over.
Great, Scott. So no new questions, but I want to remind all the attendees, Scott's contact information is on the screen right now. So if you want to reach out directly to him, please do so. We'll be sending a copy of the PowerPoint and a link to the recording to all the registrants in an email in the next couple of days, so expect to see that. I don't see any additional questions, so I'd like to thank you, Scott, for joining us, and the content was excellent as usual. And I'd also like to thank everyone else for joining us today.
Wonderful. Thanks for having me on.